2024 revisions to Florida Condo law regarding conflicts of interest. Section 2. Section 468.4335, Florida statutes, is created to read 468.4335 Conflicts of Interest. 1. A community association manager or a community association management firm, including directors, officers, and persons with a financial interest in a community association management firm or a relative of such persons, must disclose to the board of a community association any activity that may reasonably be construed to be a conflict of interest. A rebuttable presumption of a conflict of interest exists if any of the following occurs without prior notice. A community association manager or a community association management firm, including directors, officers, and persons with a financial interest in a community association management firm, or a relative of such persons, enters into a contract for goods or services with the association. B. A community association manager or a community association management firm, including directors, officers, and persons with a financial interest in a community association management firm, or a relative of such persons, holds an interest in or receives compensation or anything of value from a corporation, limited liability corporation, partnership, limited liability partnership, or other business entity that conducts business with the association or proposes to enter into a contract or other transaction with the association. 2. If the association receives and considers a bid that exceeds $2,500 to provide a good or service, other than community association management services, from a community association manager or a community association management firm, including directors, officers, and persons with a financial interest in a community association management firm, or a relative of such persons, the association must solicit multiple bids from other third-party providers of such goods or services. 3. If a community association manager or a community association management firm, including directors, officers, and persons with a financial interest in a community association management firm, or a relative of such persons, proposes to engage in an activity that is a conflict of interest as described in subsection 1, the proposed activity must be listed on, and all contracts and transactional documents related to the proposed activity must be attached to the meeting agenda of the next Board of Administration meeting. The disclosures of a possible conflict of interest must be entered into the written minutes of the meeting. Approval of the contract, including a management contract between the community association and the community association manager or community association management firm, or other transaction, requires an affirmative vote of 2/3 of all directors present. At the next regular or special meeting of the members, the existence of the conflict of interest and the contract or other transaction must be disclosed to the members. If a community association manager or community association management firm has previously disclosed a conflict of interest in an existing management contract entered into between the board of directors and the community association manager or community association management firm, the conflict of interest does not need to be additionally noticed and voted on during the term of such management contract, but, upon renewal, must be noticed and voted on in accordance with this subsection. 4. If the board finds that a community association manager or a community association management firm, including directors, officers, and persons with a financial interest in a community association management firm or a relative of such persons, has violated this section, the association may cancel its community association management contract with the community association manager or the community association management firm. If the contract is canceled, the association is liable only for the reasonable value of the management services provided up to the time of cancellation, and is not liable for any termination fees, liquidated damages, or other form of penalty for such cancellation. 5. If an association enters into a contract with a community association manager or a community association management firm, including directors, officers, and persons with a financial interest in a community association management firm, or a relative of such persons, which is a party to or has an interest in an activity that is a possible conflict of interest as described in subsection 1, and such activity has not been properly disclosed as a conflict of interest or potential conflict of interest as required by this section, the contract is voidable and terminates upon the association filing a written notice terminating the contract with its board of directors, which contains the consent of at least 20% of the voting interest of the association. 6. As used in this section, the term relative means a relative within the third degree of consanguinity by blood or marriage. Section 3. Paragraph B of subsection 2 of section 468.436 Florida statutes is amended, and subsection 4 of that section is reenacted to read 468.436 Disciplinary Proceedings. 2. The following acts constitute grounds for which the disciplinary actions in subsection 4 may be taken. B1. Violation of any provision of this part. 2. Violation of any lawful order or rule rendered or adopted by the Department or the Council. 3. Being convicted of or pleading nolo contendere to a felony in any court in the United States. 4. Obtaining a license or certification or any other order, ruling, or authorization by means of fraud, misrepresentation, or concealment of material facts. 5. Committing acts of gross misconduct or gross negligence in connection with the profession. 6. Contracting, on behalf of an association, with any entity in which the licensee has a financial interest that is not disclosed. 7. Failing to disclose any conflict of interest as required by S. 468.4335. 8.7. Violating Chapter 718, Chapter 719, or Chapter 720 during the course of performing community association management services pursuant to a contract with a community association as defined in S. 468.4311. 4. When the Department finds any community association manager or firm guilty of any of the grounds set forth in subsection 2, it may enter an order imposing one or more of the following penalties. A denial of an application for licensure. B. Revocation or suspension of a license. C. Imposition of an administrative fine not to exceed $5,000 for each count or separate offense. D. Issuance of a reprimand. E. Placement of the community association manager on probation for a period of time and subject to such conditions as the Department specifies. F. Restriction of the authorized scope of practice by the community association manager. This is an excerpt of the 2024 revisions of the Florida Condo law that was adopted by the state legislature in March, signed by Florida Governor Ron DeSantis in June, and took effect in July 2024. This video and audio was created by Miami consultant Peter Zaleski of condovultures.com by copying and pasting the verbiage directly from the Florida Legislature website. The audio is an AI-generated voice. To obtain a digital written copy of the changes to the Florida Condo law used for this video and/or audio, please visit https://laws.flrules.org/2024/244. To watch and/or listen to a narration of all of the 2024 changes to the Florida Condo law, please visit http://www.condovultures.com/.